Hey guys, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. So it's what is it, 2:20 here in Australia? So I'm not gonna. This is gonna be a short one. Also, the hotel Wi-Fi is crap, so I might be breaking up a little bit. Hopefully, it'll work. So if I pause and cut in and out, I apologize in advance. But I'm gonna try to make this, like I said, quick. So here we go. That's not it. Nope, that's it. There we go. Hopefully, you guys can read that. Okay, so the judge actually ruled on all the motions to dismiss. Somebody says, "Oh my God, this is gonna make people spiral." I agree. I agree. But it's maybe not as bad as some people think. And I know that sounds weird, but let me just get through this first. I'm not going to go through the whole document. Obviously, it's 132 pages, and like I said, it's 2:30 in the morning, so I gotta chill. But we'll go over the main points here. Let's see. Okay, so all these parties had moved to dismiss the amended complaint of the Wayfair parties. Also, Reynolds, Sloan, and Vision PR additionally moved for an award of attorney's fees and costs pursuant to New York's anti-SLAPP law. Okay. Lively moves for an award of attorney's fees, treble damages, and punitive damages pursuant to California Civil Code Section 47.1, which is what people have been talking a lot about lately. Finally, Lively, Sloan, and Reynolds moved to strike Exhibit A to the amended complaint pursuant to Federal Rules of Civil Procedure 12F. For the following reasons, the motions to dismiss are granted. The motion to strike is denied, but the court will disregard Exhibit A to the amended complaint for purposes of this motion. So Exhibit A was that timeline with all the with all the text and everything. Hold on, sorry. The motions for fees are denied without prejudice to renewal. Okay. And like I said, it's maybe not as bad as it sounds because they were, given an opportunity to amend their complaints, and those amended complaints are now going to be due on June 23rd. What is that, 2 weeks from today? Let me see. Yeah, 2 weeks from today. So this is not like the judge isn't throwing it out and saying this is it, it's over. They just have to amend the complaint, you know, within 2 weeks now. So, which I think it's possible they were expecting that. So, and then remember, Justin and Wayfair, they did not move to dismiss any of the Lively parties or, Sloan, whatever. They didn't move to dismiss any complaints against them. They had just responded to them. So the only motions to dismiss that were, present to rule on were the ones against the Wayfair parties. So, all right. Half of us coming from Ashley's live. Oh, is Ashley live? I just happened to wake up, like I happened to roll over in the middle of the night, right at the right time. It was so weird, but works out for me. How about pertaining to defamation? Everything that was granted, the motions to dismiss everything were granted, but they have to amend the complaints now. So, no, she just ended 5 minutes ago. Okay, gotcha. All right, let's see. Like I said, I can't go through all this right now because it's 132 pages in the middle of the night, but let's see. He's given some background on this. We don't need to really rehash that, so I'm going to skim over it. Okay. Yeah, there's no way I can go through word for word all of this right now. Obviously, I'll post a link to this in the comments. So, parties, we're not going to obviously go over that. And I know Leanne is probably working on something with this over on X. So, okay, return to set of the end of production, and there's that 17-point list of demands. Anyways, he's just giving background on the complaints here, which is something that we pretty much know in depth. I think the judge did well here, actually. I mean, maybe it's not Like I said, I don't think it's as bad as it sounds. It's honestly not too crazy. Some of the stuff that was pointed out in the motions to dismiss did kind of make sense, especially that Exhibit A with the timeline and stuff like that. You're not normally supposed to do that with a complaint, so it makes sense. But they can do it again, like just Ricardo says here. Judge basically says try again, so it's not. Yeah, like I said, it's not terrible. Not saying Blake is innocent. Hold your horses. Yeah, I'm just reading the comments now, guys. Yeah, I'm not too worried about that. And I'm sure Omar will go over it as well. Actually, I should talk to him because I'm going back to Omar's house. I'm flying back to LA in a few hours, but it'll take me a while to get there, so we'll see. Oh, look, the judge has the emojis in his. Okay, sorry, that's really funny. I can't believe that upside down smiley emoji was such a big deal in all this. All right. Procedural history. Okay, so that's just talking about what's been going on here. Legal standard. Okay. The amended complaint focuses broadly on two types of claims. First, the Wayfarer parties claim that Lively, assisted by Reynolds and Sloan, stole the film from Baldoni and Wayfarer, threatening to refuse to promote the film and attack Baldoni and Wayfarer in the press if the Wayfarer parties did not agree to grant her, rather than Wayfarer, control over and credit for the film. Parties seek damages for this conduct based on a legal theory that Lively, Reynolds, and Sloan committed civil extortion. Second, the Wayfarer parties claim that Lively, Sloan, Reynolds, and the Times spread a false narrative that Baldoni committed sexual misconduct towards Lively, and the Wayfarer parties then engaged in a smear campaign to ruin her reputation. The Wayfarer parties claim that by doing so, Lively, Reynolds, Sloan, and the Times committed the torts of defamation and false light. Although these two types of claims are the focus of the amended complaint, the Wayfarer parties also bring claims for breach of contract, tortious interference with contract or prospective economic advantage, and promissory fraud. The Wayfarer parties cannot recover for Lively's alleged actions to steal creative control of the film from Baldoni and the Wayfarer parties. Regardless of the propriety of these actions, they do not constitute civil extortion under California law. California courts have recognized a claim for civil extortion in situations where a plaintiff gives a defendant money or property under threat and seeks to have it returned. However, the Wayfarer parties have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible hard bargaining or renegotiation of working conditions. Additionally, the Wayfarer parties have not shown that some of Lively's allegedly extortionate acts damaged them. So they're just going to have to do that when they write their new one. The Wayfarer parties also cannot recover on their defamation claims. They've not alleged that Lively is responsible for any statements other than the statements in her CRD complaint, which are privileged. The Wayfarer parties have alleged that Reynolds and Sloan made additional statements accusing Baldoni of sexual misconduct, and that the Times made additional statements accusing the Wayfarer parties of engaging in a smear campaign. But the Wayfarer parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information available to them, as is required for them to be liable for defamation under applicable law. The Wayfarer parties' additional claims also fail. Accordingly, the amended complaint must be dismissed in its entirety. However, the Wayfarer parties have leave to amend their claims for breach of implied covenant and tortious interference with contract. Somebody says months back the judge already hinted they should amend, and Friedman declined. Well, remember they had asked for an extension at one point, and then he said, no, we need to stick to the schedule that we agreed to in that February 3rd conference. And then Brian wrote that letter to the judge and said they don't intend to voluntarily amend by the deadline. So, yeah. Okay. And remember, there's not going to be anything about like the Van Zandt stuff in here or anything like that, because that's not in the amended complaint. And they actually haven't really asked him to do anything in regards to that. So we're not going to see anything, especially in this document. that's going to tell us anything about that, really. So maybe that's something that'll come up, but okay. Choice of law. The Wayfarer parties plead their claims under California law. Lively agrees with the Wayfarer parties that California law applies to the claims asserted against her. However, Sloan, Reynolds, and the Times argue that New York law applies to these claims against them. This dispute is important because New York and California law differ in a number of ways relevant to the Wayfarer parties' claims. Okay. New York law does not recognize causes of action for civil extortion, false light invasion of privacy, or negligent interference with prospective economic advantage. In addition, although elements of defamation under New York and California law are generally similar, the New York Constitution provides independent protection for statements of opinion, and the two states have different statutory privileges against defamation. As to the claims against Sloan and Reynolds, the court is unable to determine what law applies at this stage. Okay. The Wayfarer party's defamation and false light claims are based on allegations that Sloan made false statements in text to a Daily Mail reporter, that Reynolds made false statements that Baldoni was a sexual predator, and that both Sloan and Reynolds participated in a campaign to leak false information to the press, all of which occurred at unspecified locations. The civil extortion and false light claims against Sloan and Reynolds are based on essentially the same allegations as are the claims for tortious interference against Reynolds. Because it is unclear from the pleadings where the facts underlying the claims against Sloan and Reynolds occurred, the court cannot dismiss the claims based on a holding that they must be brought under New York law. If the allegations state a claim under California law, the claim must be allowed to continue until such time as the facts developed show California law does not apply. Therefore, the court will analyze the claims against Sloan and Reynolds under California law for purposes of this motion. Okay, so he's applying California law here for this. The defamation and false light claims against the Times must be analyzed under New York law. The Wayfarer parties argue that these claims are properly brought under California law because they are California citizens and feel the impact of the defamation in California. But the Second Circuit analyzed a similar situation in Kingsley versus the New York Times, in which the Times published an allegedly defamatory article regarding events that took place in the District of Columbia and affected the plaintiff's employment there. Okay. Carolina, thanks for the 5. Everyone waiting for Lauren to hop on from vacation. Take time to tip her. You're good, man. Thank you, though. Thank you. I appreciate that. It's very nice of you. Well, I mean, it's pretty much over at this point. Like I said, my flight out is in 7-8 hours. All right. The circuit distinguished between defamation cases involving a targeted publication in which the state of the plaintiff's domicile will usually have the most significant relationship to the case, and multi-state defamation cases in which an allegedly defamatory statement is published nationally and the plaintiff suffers harm in every state simultaneously. The circuit stated that in multi-state defamation cases, the traditional rule that the law of the plaintiff's domicile applies is only presumptive and may be overcome if some other state has a more significant relationship, taking into account where the plaintiff suffered the greatest injury, where the statements emanated and were broadcast, where the activities to which the allegedly defamatory statements refer took place, and the policy interests of the states whose law might apply. The circuit then held that although the plaintiff suffered the greatest injury in the District of Columbia and Maryland, New York had the most significant interest in the litigation because the Times is domiciled in New York. The allegedly defamatory statement emanated from New York, and New York has the strong policy interest in regulating the conduct of its citizens and its media. Okay. The same factors require application of New York law to the defamation and false light claims against the Times here. Okay, so we're going to skim over that then. Impermissible pleading. We heard a lot about that. All defendants argue that the amended complaint should be dismissed without further analysis because it engages in impermissible group pleading and otherwise violates Federal Rule of Civil Procedure 8. Okay. Under Rule 8, a complaint is required to give the adverse party a fair notice of the claim asserted so as to enable him to answer and prepare for trial. Defendants argue that they lack proper notice of the claims against them because the amended complaint consistently makes allegation regarding the lively parties and the Wayfarer parties, leaving defendants unable to discern which of them purportedly injured with which plaintiff and how. Okay. I'm going to skim over some of this, guys. Although the amended complaint lacks clarity as to the boundaries of certain claims, defendants have adequate notice of many core claims that are evident from the face of the complaint and have been fully briefed by the parties. For example, it is evident from the language of the complaint that the civil extortion claim is based on Lively refusing to promote the film unless she was allowed to create her own cut. Lively demanding with extortionate threats that Baldoni and Heath support her PGA certification. God, sorry, I'm reading this, I'm just remembering everything that she reportedly did, and it's just Jesus. Okay. Do you ever just forget? Like, there's just so much that you just forget some of it sometimes, and then it comes back up, and you're like, oh, fuck, that's right. I need a summary at the end. It's hard to understand it all. I mean, there might be one. I don't know, but I've not gone over this obviously beforehand, so I can't really give you a summary right now. Okay. So we had the refusing to promote the film unless she could get her own cut, and then she was making them support her PGA certification, and Lively and Reynolds attempting to force Baldoni and Wayfarer to read a statement apologizing for issue with the film. It is evident that the defamation claim is based on Lively, Sloan, and Reynolds providing the CRD complaint to the Times before it was released, and stating to the Times in substance that the Wayfarer parties engaged in sexually inappropriate conduct towards Lively and retaliated against her for reporting the misconduct by engaging in a campaign to ruin her reputation. Sloan and Reynolds making additional statements that Baldoni had committed sexual misconduct, and the Times stating that Baldoni, Heath, Abel, and Nathan had engaged in a smear campaign to ruin Lively's reputation. None of this, by the way, means that the judge thinks there was a smear campaign, or anything like that. So don't take it that way. That's not okay. I'm just not going to get into that. Where the amended complaint does lack clarity, the court will consider only the claims of which defendants have fair notice. To the extent a fair reading of the amended complaint does not provide notice that the Wayfarer parties are making a particular claim against a particular defendant based on a particular statement, the court will not parse through the various allegations and documents to determine whether a claim could theoretically be stated. For example, although the amended complaint alleges the CRD complaint was rife with lies and doctored evidence, the court will not consider whether the CRD complaint contained any defamatory statements beyond those specifically alleged in the amended complaint. Similarly, in analyzing the defamation claim against the New York Times, the court will not consider whether any statements in the article are defamatory beyond those identified in the amended complaint. The Wayfarer parties have an obligation to identify the statements which harmed them rather than gesturing at a document or category of statements and forcing the defendant to guess at which ones are actionable. I mean, that makes sense. Likewise, if the complaint uses the Lively parties or Wayfarer parties in a context where a particular plaintiff or defendant is not clearly indicated, the court will not guess at what claim the amended complaint is attempting to make. Such a course would promote litigation by ambush. Where have I heard that before? I'm pretty sure it was in a Leslie Sloan document. Allowing plaintiffs to use vague pleading to hide their claims only to spring them on defendants in opposition briefing or at trial. Accordingly, though the court will not strike or dismiss any allegations on Rule 8 grounds, the court will consider only those claims that a reasonable defendant would understand to be asserted against it based on the allegations in the amended complaint. The Wayfarer party's first claim is for civil extortion under California law against Lively, Reynolds, and Sloan. Just blowing up my phone right now. Yeah. Okay. As long as it's not my mom, I'm not going to answer that. In support of this claim, the Wayfarer parties allege, 1, that Lively refused to return to production unless the Wayfarer parties agreed to her return to production demands. 2, that Lively threatened to abandon her contractual obligation to promote the film or approve marketing materials unless they agreed to co-fund a screening of her version of the film. Forgot about that too. Nice one. Okay. Eventually release that version and grant her a producer credit and support in seeking the PGA designation. That Lively threatened to boycott the premiere unless Baldoni was excluded. That Lively and Reynolds threatened to attack Wayfarer in the press if it did not take the blame for problems during filming. And 5, that Sloan carried out Lively and Reynolds' threats by spreading false allegations that the Wayfarer parties had engaged in or concealed sexual misconduct. Lively, Sloan, and Reynolds argued that none of the alleged acts are wrongful, and they did not obtain money or property from the Wayfarer parties. The Wayfarer parties argue they are not required to allege a transfer of money or property, and that the threats alleged in the amended complaint are sufficient. Lively, Sloan, and Reynolds have the better of the argument. Okay. Governing law. I'm not gonna lie to you guys. I'm probably gonna skim over a lot of this right now. The parties advance a different understanding of the tort of civil extortion under California law. Lively, Reynolds, and Sloan argued that civil extortion is a cause of action for money obtained by duress, which is separate from the crime of extortion and requires proof of actual damages. Wayfarer argues that civil extortion is a cause of action based on the criminal extortion statute and that it does not require money or property actually be obtained. Although the claim, Lively, Reynolds, and Sloan are correct. Although the claim is labeled civil extortion, it is derived from the common law rather than the criminal extortion statute and requires actual damages. K. Fitch, that's correct. No fees or damages were awarded. So, yes, they can amend. All right. We're going to skip over this part. Okay. The Wayfarer party's civil extortion claim is based on allegations: 1, that Lively refused to return to production unless they agreed to her demands. That Lively threatened to abandon her contractual obligation to promote the film. Yeah, we kind of went over the same shit above, so I'm not going to boycott the premiere unless it was included, blah, blah, blah. Yeah, we definitely read through the same thing. Okay. The last set of allegations is not actionable because Wayfarer did not acquiesce in the threat and did not accept blame for problems during filming. Wayfarer did not lose anything, and Lively and Reynolds did not gain anything from the threat. The remaining allegations must be dismissed because the allegations regarding Lively's wrongful threats are conclusory and fail to support that the threats were wrongful. So again, that's something they're going to have to fix. In addition, the Wayfarer parties have failed to plead that several key instances of alleged extortion caused actual monetary loss. Okay. The Wayfarer parties focus significantly on the demand by Reynolds and Lively that the Wayfarer parties issue a self-destructive statement taking blame for Lively's press woes, or else the gloves would come off, and they would attack Wayfarer in the press. However, they refused to issue any such statement. Accordingly, there was no reliance on the threat. The Wayfarer parties did not give up anything to Reynolds or Lively, and the plaintiff did not sustain damages cognizable in a cause of action for duress. The Wayfarer parties allege that in response to threats that Lively would stop acting in the film or breach her contractual obligations to promote it, they were forced to agree to the return to production demands, give Lively greater control over the script, give her a producer credit, and support her in seeking the PGA mark, and accept marginalization from the premiere. However, Wayfarer does not plead sufficient facts to support an interference that these threats were legally wrongful. Lively did not threaten to physically harm the Wayfarer parties or their property, nor did she threaten a false lawsuit, as in Leeper and Furman. Okay. So a lot of what I've talked about, because you guys know I'm not a lawyer, is like this kind of stuff right here. Like, they don't plead sufficient facts to support an inference that these threats were legally wrongful. So my issue with a lot of the stuff in the complaints is not like the legal aspect of things. I'm like, obviously, I don't know how this is going to play out in court. Obviously, they're going to amend here. But regardless, this was like shitty behavior that has consequences, especially in a public opinion standpoint. So I'm not surprised that obviously the public kind of turned on Blake based on her behavior and especially her promotion of the film on such a sensitive subject. Whether or not that plays out in court the way that I would like it to is another thing. But I think that there was no, real smear campaign. I think that she kind of deserved the backlash that she was getting. So, but that's just a me standpoint. Obviously, that has nothing to do with the judge. So, it's just my moral outrage. It's fine. He disregarded all Amici briefs. I don't know. I haven't gotten there. If that's in here. So, the Wayfarer party's claims do not turn on what Lively threatened to do, but what she threatened not to do. The Wayfarer parties allege that threatened to refuse to promote. However, they don't allege facts showing that she had an obligation to promote the film or to approve marketing materials. Well, that's something they could fix pretty easy, I think. They do not point to any contractual provisions, explain what Lively's contractual obligations were, or even explain what contract is being referenced. Similarly, with regard to Lively's refusal to attend the premiere with Baldoni, the Wayfarer parties do not allege that Lively had any obligation to attend the premiere with Baldoni. Okay. Wayfarer parties plead that Lively had an obligation to act in the film. They don't allege she had such obligation no matter the circumstances. A refusal to provide that which one has no obligation to provide is not a threat. It is a bargaining position. Conclusory allegations are insufficient to plead a breach of contract and are therefore insufficient to plead that Lively threatened to breach her contract. Again, that's something that should be like easily fixable. Moreover, assuming the Wayfarer parties did plead that Lively refused to do that which her contract required her to do, that would not alone be sufficient to plead that such a refusal was wrongful and could support a claim for civil extortion. A threat to breach a contract may constitute a breach or an anticipatory repudiation of a contract, but it is not of itself improper. Okay. It is thus not uncommon in commercial relationships that one or the other party will demand that a condition to their agreement change before performance is rendered. I kind of get that. Like I said, though, there's probably going to be some easy ways they can fix that in regards to the contract. It follows that not every statement that a party will stop performing a contract unless the conditions are changed or new consideration provided will give rise to a claim in tort for civil extortion. Rather, courts consider a claim to involve economic duress only under limited circumstances, generally involving the wrongful exploitation of business. What the fuck is that word? Exigencies? An urgent need or demand? Huh. I did not know that. So they were all dismissed. Rose is wild. We got some late people coming in here, so. Christina, thank you for the membership. Someone said there's a summary on the last page. Appreciate what you do. Yeah, cool. Millennial Mom, again, thanks for being a member. I hope you had a lovely trip, Lauren. I have. But I would love to get some more sleep. So let's get through this. Okay, I think that's enough of that. Like I said, I'll probably go through the whole thing with Omar later, but I'm not gonna do a word for word thing right now. There are no allegations supporting Reynolds or Sloan's liability. The Wayfair parties argue that Sloan and Reynolds are liable in conspiracy because by actually spreading defamatory statements, they played the role of the heavy carrying out Lively's extortionate threats. Huh? All right. However, the only instance in which Lively and Reynolds allegedly threatened to spread defamatory statements was in demanding that the Wayfair parties make a harmful public statement. As stated above, the Wayfair parties never provided such a statement, so no conspiracy related to the statement is actionable. In addition, if Sloan and Reynolds actually spread defamatory statements, they would be liable in defamation, not civil extortion. Finally, the Wayfair parties' allegations regarding the purported conspiracy to commit civil extortion are entirely conclusory. The Wayfair parties bring defamation claims against all defendants. The allegedly defamatory statements are statements to the effect that one, Wayfair engaged in, permitted, and/or failed to prevent sexually inappropriate conduct towards Lively, and two, the Wayfair parties retaliated against her and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Let me move that real quick. There we go. The Wayfair parties allege that Lively, Sloan, and Reynolds engaged in a conspiracy to spread these defamatory narratives to the Times, other media outlets, and Baldoni's agency, and that the Times committed defamation by publishing the same narratives. These allegations fail to state a defamation claim. The court refers to California law in setting out the legal standard for defamation, leaving any distinguishing aspects of New York law for discussion as applicable to the Times. Although some applicable statutes and privileges differ, the elements of defamation in both states are similar. Okay. It's talking about defamation in regards to a private versus a public figure, which I'm not going to get into right now. Okay. Talking about the fair and true report privilege. The Wayfair parties allege generally that Lively, Sloan, and Reynolds worked together to advance a fabricated narrative in the press that the Wayfair parties had sexually harassed Lively, then embarked on a calculated and malicious smear campaign to destroy her reputation as retaliation for daring to complain about the harassment. This general allegation has multiple facets. Most prominently, the Wayfair parties allege that Lively, Sloan, and Reynolds worked together to spread a false narrative to the Times. In addition, the Wayfair parties alleged that as part of the same conspiracy, Sloan and Reynolds individually made false statements about Baldoni to other press outlets and Baldoni's agency. The Wayfair parties have not adequately alleged a defamation claim as to any part of the purported conspiracy. They haven't alleged that any false statements were made to the Times other than the statements in Lively's CRD complaint, which were privileged under California law. There also is no allegation that the distribution of that the distribution of the CRD complaint was made by anyone other than Lively, or more particularly with the involvement or agreement of Sloan or Reynolds. The Wayfair parties have not adequately alleged that Sloan or Reynolds individually did any more than repeat Lively's version of events, which they had no reason to doubt. And the Wayfair parties have not adequately alleged that Lively should be held responsible for Sloan or Reynolds' statements. Their allegations of a conspiracy between the parties are conclusory. The Wayfair parties' claims of defamation against Lively, Sloan, and Reynolds are partly based on allegations that Lively and her team made false statements about the Wayfair parties to the New York Times. A fundamental obstacle to this claim is that the Wayfair parties do not plead and may not know exactly what, if anything, the Lively parties and the New York Times communicated to each other. Accordingly, the amended complaint fails to allege facts regarding who said what, if anything, to the New York Times and when. The amended complaint instead relies on inferences from the fact that the Times had the CRD complaint before it was publicly available and on conclusory and often dramatized allegations. Okay, man. Thanks for that. And often dramatized allegations, sometimes on information and belief, that the lively parties worked together to feed the Times a false narrative, apparently based on text messages that were selectively and deceptively edited, that the Wayfair parties had responded to Lively's complaints about purported sexual harassment by plotting to destroy her reputation via a smear campaign. A plaintiff who is unable to plead direct facts must at a minimum plead circumstantial facts supporting a plausible inference that the defendant's behavior crossed the line from lawful to unlawful conduct. The factual allegations pleaded in the amended complaint do not state a claim. They support at most the plausible inference that Lively or someone acting on her behalf provided the Times with a copy of the CRD complaint and related text messages before the complaint was filed. While the article was published on December 21st, the day after Lively filed her CRD complaint, the Times asked the Wayfair parties to comment on the article at 9:46 p.m., reporting on the CRD complaint on December 20th, the same day it was filed. There is a powerful inference that the Times had access to the CRD complaint well before that date. The article and CRD complaint are both purportedly based on thousands of pages of text messages and emails that Lively obtained through a subpoena, which the article states were reviewed by the New York Times. And we all know about this subpoena now, but like I said, it wasn't in the amended complaint, so that's probably not going to be addressed here. Okay. URLs for images, PDFs, and videos associated with the article contain the dates of December 12th, December 10th, and December 16th. The article draws heavily from Lively's CRD complaint. It would have taken time to review that complaint and its attachments. In addition, source code for a portion of the article contains the date October 31st. And because the Times had access to the CRD complaint before it was filed, and while it was still confidential, there is also a powerful inference that it was provided by Lively or someone on her team. Lively obviously had access to the CRD complaint before it was filed. It only makes sense that the CRD complaint was given to the Times by Lively or someone acting on her behalf. If the complaint was provided to the Times, it is highly likely that Lively played a responsible part. The act of providing the CRD complaint to the Times is not sufficient to constitute defamation because the complaint is protected by the fair report privilege. The CRD complaint is a filing in a quasi-judicial proceeding. The Wayfair party's main response is that the privilege does not apply because at the time Lively provided the CRD complaint to the Times, it had not yet been filed in an official proceeding. However, under California law, a party need not wait until a legal document is formally filed before providing it to members of the press. The fair report privilege extends to advance communication to a public journal of a complaint so long as the party intends in good faith to file it in a public official proceeding. I'm not a fan of that. The fair report privilege originally applied only to reports in a public journal, not communications to that journal. In 1996, however, California legislature extended the privilege to protect individuals who communicate litigation statements to the press. Here, there's no basis to infer anything other than that litigation was actually contemplated seriously and in good faith. In the first place, Lively commenced litigation. She filed it within months of the events described in the complaint, and not long after it was plausibly given to the Times. 11 days after she filed the CRD complaint, Lively filed suit in this court, making the same allegations that she made before the CRD. The Wayfair parties assert that the fact that Lively eschewed the administrative process and filed suit in federal court instead demonstrates that she did not file her claim in good faith. But the conclusion does not follow from the premise. It is a requirement under California law that before suing for any violation of the California FEHA, a plaintiff must file a timely and sufficient administrative complaint with the CRD. The CRD then issues a right to sue notice, allowing the plaintiff to proceed to court. The court, but not the agency, is authorized to award either punitive or general compensatory damages. Thus, the fact that Lively chose to file in federal court rather than continue in the administrative process does not deprive her of the benefit of the privilege. Lively's actions support rather than detract from the inference that the administrative complaint was filed as part of a genuine attempt to pursue Lively's claims. It was only by filing the complaint that Lively was able to pursue the claims she's pursuing. To be sure, as the Wayfarer parties argue, the fair report privilege does not protect litigating in the press, and the fair report privilege does not extend to communications which go beyond the allegations in a judicial proceeding or which communicate the alleged facts without reference to the complaint. The amended complaint plausibly alleges that Lively provided the Times with text messages and emails that are not included in the CRD complaint. The article suggests the Times reviewed thousands of pages of text messages and emails, and the article includes messages that are not in the CRD complaint at all. But that says at 11. But however, the Wayfarer parties do not allege that any text messages and emails not included in the CRD complaint and that could have been provided to the Times were defamatory. Again, that's probably something that's easily fixable. But they're going to need the communications between her and the Times, I guess, to see everything that she gave them. Right. Bixio Music Group, thank you for the 10. Thank you, Lauren. Love Miriam. Thank you. I appreciate you. And Lottie, thank you for the 10. Awesome. You guys are awesome. Thank you. Okay. Okay. So, like I said, if they can see what she had sent them or what they had gone over, the thousands of pages of whatever, then maybe they can fix that. The messages in the article and video providing the strongest support for the smear campaign narrative are those included in the CRD complaint, with those not included lending minimal, if any, additional support to this narrative. On the contrary, the messages discussed in the article, but not in the CRD complaint, are often supportive of Baldoni's narrative. Okay. The amended complaint alleges that the Times had access to a plethora of communications, demonstrating that Lively's narrative was not true. But if Lively provided messages to the Times reflecting that a smear campaign was not waged, that would not be defamatory of the Wayfarer parties. The Wayfarer parties additionally allege that Lively provided the Times with text messages that were apparently selectively and deceptively edited, but that does not add to her claim. The amended complaint alleges that the selective and deceptive editing was simply the editing of the CRD complaint, that in the CRD complaint, Lively provided excerpts of messages that were deceptively edited. And then there's the upside down guy again. The Wayfarer parties assert, as litigants frequently will assert, that the version of offense recited by their adversary is selective and does not tell the whole story, but the claim that the CRD complaint painted a deceptively favorable picture in favor of Lively and took quotations out of context does not deprive Lively of the litigation privilege. A litigant is not required to file a balanced pleading before an agency or in court. Well, that's for sure. She is permitted to marshal the facts to tell her side of a contested story. And an adversary cannot invoke the law of defamation and defeat the privilege by contending that the allegations are untrue. That doesn't mean that the allegations are not untrue. Just, Okay. If the CRD complaint was privileged, as the court has held it was, the addition of the claim that it contains selectively edited emails thus does not do away with the privilege. To the extent that the Wayfarer parties mean to assert that the Wayfarer parties separately sent the Times selectively edited messages beyond merely providing the Times with a CRD complaint, I think they mean the Lively parties there. No facts support that conclusory allegation. If Lively wanted to paint an overly rosy picture of her narrative and did so by selectively quoting messages in her CRD complaint, there's no reason why she would have needed to provide the Times with other selectively edited messages. No such other selectively edited messages are pleaded. Well, I disagree with there's no reason why she would have needed to do that, because there's a decent chance that they may have asked her for more, you know what I mean? Like, if we're gonna go ahead with this, we wanna see more evidence. The amended complaint insinuates that in addition to leaking the CRD complaint and providing the Times with related messages and emails, Lively, Reynolds, or the Sloan parties could have made other unspecified communications pressing their version of events. Okay. But they allege no facts to support those insinuations. Okay. Yeah, so I'm going to skim over the rest of this again. The sexual assault and sexual predator statements. They separately allege that Sloan and Reynolds made defamatory statements that Baldoni was a sexual predator or committed sexual assault. Specifically, the amended complaint alleges that Sloan told a Daily Mail reporter that Lively was sexually assaulted, and Reynolds told a WME executive and Baldoni's agent that Baldoni was a sexual predator. The Wayfair parties have not alleged these statements were made with actual malice. Their claim thus fails. Okay. A false accusation of sexual assault or similar sexual misconduct can support a defamation claim. Sexual assault is a crime, and an allegation of criminal activity is defamatory per se. A statement that an individual committed sexual assault would generally be understood as a statement of fact. Okay. Likewise, in the context of It Ends With Us and Reynolds' relationship with Lively, the comments from Reynolds that Baldoni is a sexual predator could reasonably be understood as a claim of fact that Baldoni had engaged in sexual misconduct towards Lively. However, the Wayfair parties have not alleged that Sloan or Reynolds had knowledge that the statements they are alleged to have made were false, or that they entertained serious doubts as to their truth. Because Baldoni is a public figure, he may only recover if the statements were made with actual malice, meaning actual knowledge of falsehood or reckless disregard for the truth. At the pleading stage, a plaintiff in federal court cannot simply state in a conclusory fashion that a defendant knew a statement was false. He must plead facts demonstrating that the claim of actual malice is plausible. Dad wants to go to the movies Sunday, but it's a popular one, so what time can you go? I don't know. I'll be asleep on Sunday. Sorry, this is my sister. Okay, I'm not going to go through each of these individual ones here right now. In fact, it's 3:15 in the morning. Why don't I just skip to the summary? Sorry, give me one sec. All right, we're just going to skip to the end here. Hang on. Yeah, because I don't see like an actual summary here. So we'll go through this though. Okay. This is for leave to amend. The Wayfair parties seek leave to amend their complaint to cure any pleading defects. The Wayfair parties' proposed amendments would 1. Cure impermissible group pleading, 2. Include additional facts relevant to choice of law, 3. Address the fair report privilege and actual malice as applicable to the New York Times, 4. More fully incorporate the allegations in Exhibit A, amend allegations relevant to the civil extortion claim, amend the false light claim, 7. Add additional allegations of conspiracy to defame, 8. Specify that Lively's contract requires that her right to consult and approve on the film be exercised in a reasonable manner and not frustrate Wayfair's production and development rights. And 9. Adequately allege Baldoni's contract with WME in support of the tortious interference with contract claim. Defendants oppose leave to amend on the ground of futility and undue delay. Okay. When a motion to dismiss is granted, the usual practice is to grant leave to amend the complaint. However, it is well established that leave to amend a complaint need not be granted when amendment would be futile. The court will not grant leave to amend the majority of the Wayfair party's claims because amendment would be futile. The dismissal of the claims does not rest on technical pleading defects, and the Wayfair parties have not made a showing that the complaint's defects can be cured. The Wayfair parties do not identify any particular factual allegations that could be added to support the defamation or civil extortion claims, nor is it plausible that any allegations not yet mentioned would change the basic substance of Lively's threats, the conclusion that the CRD complaint was privileged, or the conclusion that relevant statements were made without actual malice. In addition to their 224-page amended complaint, the Wayfair parties have already submitted to this court an additional 168-page exhibit with additional details relevant to their claims. Although the exhibit is not properly considered for purposes of the motion to dismiss, the allegations within it still would not allow the Wayfair parties to state a claim. The exhibit contains additional detail on Lively's threats, but if anything, these details cut against a finding of extortion. For example, the exhibit details that for some time, Sony and Wayfair, in fact, resisted Lively's requests, stating this is a Wayfair movie, Wayfair has final cut and runs the process. It then states that Lively did not sign her acting agreement so that she could continue to leverage her promotional participation as a bargaining tool, implying that Lively may not have had a contractual obligation towards Wayfair to promote the film. Incorporating these facts would not aid the Wayfair parties in alleging that her threats were legally wrongful and could not be resisted. If, in fact, Lively did not owe the Wayfair parties an obligation to promote the film, her demands regarding what she would need in order to comply with their request that she engage in promotion would not have been wrongful. They would constitute hard bargaining. Similarly, although Exhibit A contains a number of messages between Wayfair not included in the amended complaint, these messages are consistent with those included in the amended complaint and would not show that the New York Times acted with actual malice. Given that the Wayfair parties have already provided an extensive record of facts that purportedly portrays their claims in the best possible light, the promise that more unspecified facts will now change the central aspects of their core claims suggests a dilatory motive to extend the litigation rather than a legitimate belief that amendment will alter the court's determination. However, the court will grant leave to amend the claims for tortious interference with contract and breach of implied contract. The Wayfair parties failed to plead the specific details of any contract between Baldoni and WME, but suggest in their briefing that this defect is easily curable and that they will plead an oral or implied contract of which Reynolds was aware. Given the allegations that Reynolds told WME to drop Baldoni, it cannot be said that repleading this claim on such terms would be futile. Similarly, the Wayfair parties assert they are able to allege the details of Lively's contract with Wayfair, including that her right to consult and approve on the film be exercised in a reasonable manner. Without seeing the contract, the court cannot say amending the breach of contract. Oh my gosh, Lauren, wake up! Amending the breach of implied covenant claim would be futile. So yeah, it sounds like he's allowing them to amend these. Hang on, leave to amend the claims for tortious interference and breach of implied contract, but the rest of it sounds like the rest of it's going to be thrown out. But so that's not great. Motions for fees. Let's see. The court denies the motions without prejudice. These are the motions for fees. In accordance with the ruling here, the court has ruled the law applicable to the claims against Reynolds and Sloan cannot be determined absent further factual development. The court has not ruled on whether Lively's statements were privileged under California Civil Code Section 47.1. If defendants choose to renew their motions, they shall fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. The motions to dismiss are granted. The Wayfair parties have leave to file a second amended complaint by June 23rd, amending only the allegations relevant to the claims of tortious interference with contract and breach of implied covenant. The motions to strike are denied. The motions for fees and damages are denied without prejudice to renewal. So yeah, it sounds like most of this is thrown out then. So it is not it's not good, but it's really bad. I mean, unfortunately, I saw somebody on Twitter had mentioned that they had, permission to amend their complaint, and I thought it was like in regards to everything. But this is unfortunately only going to apply to those two claims. So, wow, so you can ruin a person's life in New York and not get punished. Man, I'm not gonna lie to you, like there's a lot of shitty things people can get away with legally, you know? It's unfortunate, but that's true. This all sounds pretty damn bad to me. I mean, yeah, it's not good. So, unfortunately, I thought oh, hey Omar. What in the hell just happened? Uh what are you doing, man? Are you at work right now? If not, maybe now would be a good time to talk about this. I'll text you. Lily May, thank you for the $8. Thank you for this update, Lauren. Hope your stay in Oz has been enjoyable. Thank you very much. I appreciate you. Jacqueline O'Neill, thank you for the 2. Living in a twilight zone. Yeah, I know. I know what you mean. Give me a couple hours. I mean, I'm going back to bed, so, but I'll text you and we'll figure something out. Because I could probably hop on again before my flight. That'd be a good idea. All right. He isn't even allowed to defend his name. Well, he still is allowed to defend his name in that, like, he's going to defend himself against Blake's claims, which, he still has every right to do that. So, Blake wins, all of Justin's claims dismissed against everyone. That's okay. That she doesn't necessarily like win everything, you know what I mean? But it's not good. Yeah. Okay, guys. I gotta go back to bed. We'll be back pretty soon, it sounds like. Be better. I'm not trying to be dramatic, but this is making me sick. Justin needs to do an interview now. Hey, I know what you mean, man. I know. Justin, I'm not gonna lie to you, like, never met or talked to Justin, but he sounds very much like somebody who just wants to focus on his family. You never hear him say a bad word about anybody. He seems like a very like emotional guy who's very hard on himself. And so I think that maybe honestly doing an interview right now is not the best move for him, especially with the ongoing court case. Remember, this is just the one side that got dismissed. So there's a whole other side to this that, uh, will have to be fought in court. So, but I totally get what you mean, man. And it's very sad. So, okay, I'll see you guys soon, guys. I gotta go to bed. Seriously, I'm starting to lose my mind because I'm sleepy. Bye.